Let's turn, though, to your work for detainees at Guantanamo Bay. First off, let me just ask, do you think most detainees at Guantanamo Bay were mostly terrorists or mostly, I don't know, innocent goat farmers?
Senator, it's impossible for me to answer that question. The people at Guantanamo Bay had been accused by the government of engaging in terrorist activities and therefore classified by the executive branch as enemy combatants.
Okay, do you think America would be safer or less safe if we released all the detainees at Guantanamo Bay?
Senator, I'm trying to figure out how to answer that question. 9/11 was a terrible attack on our country, and the executive branch, pursuant to authority that the Supreme Court said it had, designated people as enemy combatants and sent them to Guantanamo Bay. The Supreme Court also said that anybody who was so detained could seek review of their detention. And as a federal public defender, my role and responsibility was to make arguments in defense of the Constitution and in service to the court that was trying to assess, based on the authority given to it by the Supreme Court, whether or not people were adequately classified, what the legal circumstances were, how these habeas petitions were going to be processed. This was a series of legal challenges in a novel environment that federal public defenders and lawyers across the country were engaged in helping the court to evaluate so that we can understand what the Constitution required in this time of emergency.
Okay, so no opinion on whether America would be safer or less safe if we released all the detainees from Guantanamo Bay?
Senator,
Okay.
America would be less safe if we don't have terrorists out running around attacking this country. Absolutely. America would also be more safe in a situation in which all of our constitutional rights are protected. This is the way our scheme works. This is how the Constitution that we all love operates. It's about making sure that the government is doing what it's supposed to do in a time of crisis. As Justice Gorsuch said, the Constitution is not suspended in times of crisis. The government still has to follow the rules. And so criminal defense lawyers make sure that in times of crisis, the government is following the rules.
Okay, let's turn to the actual cases. How many of these terrorists at Guantanamo Bay did you represent?
When I was a defender, 4 cases were assigned to me in our office. I don't know how many cases came into the office in total, but
You personally had 4.
I was assigned to them along with another defender who worked on the same cases. She was more senior. She did all of the sort of fact gathering related to the cases, and as an appellate defender, I worked on the legal arguments.
Okay. Did you ever represent any of the detainees at Guantanamo Bay when you were not a public defender?
One of the people who I'd represented while I was in a federal defender, his case got spun off and taken up by a law firm. Law firms around the country were also engaged in this work.
I'm well
at
aware
the
of what
time.
law firms were doing at the time.
Yes. And I left the federal public defender's office. I joined a law firm, and one of the people that I had represented was now at that law firm. They had him as a client.
That's Mr. Al-Sawam.
Al-Qatani
Al-Qatani was the one.
was the one who
Just coincidentally, Both he and you went to Morrison and Foerster.
Yes, Senator.
Okay. What about Mr. Al-Sawam?
I don't know what happened to Mr. Al-Sawam.
You were listed as counsel for 2 years during your time at Morrison and Foerster.
What happens is when you leave from any place, firms or government service, you have to let the court know, or their records reflect where you are in the system, and not so much the case in terms of your address.
So to go back to Mr. Al-Qatani,
yes.
He just coincidentally, it's a small world, went to Morrison and Foerster at the same time you did, and then you represented him, and you did file multiple motions on his behalf.
So I don't know if it was at the same time. I'm not sure.
But you did file multiple motions for him, 2008 and 2009.
I don't recall whether it was multiple, but he was still at the habeas stage of the process. And I don't know when he came, because the partners who picked up the case were in Los Angeles. I was in Washington, D.C. They contacted me to say, oh, we see on the docket that you had previously represented him, and now you're with our firm. Will you assist us with looking at these briefs, working on these briefs? There were many lawyers who were working on the filings that you're talking about.
After you left the public defender's office, did you continue in your representation of any other client you had at the public defender's office?
I didn't continue my representation of any client. I left the federal public defender's office and then picked up Mr. Al-Qatani through the circumstances that I talked about, and there were no other clients that I represented in that way.
I have to say, that sounds like continuation. You represented him at the public defender's office, and then you represented him in private practice as well. And you're telling us that's the only person you represented at both the public defender's office and in private practice?
Yes.
So you didn't continue to provide any kind of pro bono work for murderers or rapists or anyone else, but you did continue to represent this terrorist at Guantanamo Bay?
When I got to the firm and they told me that the case was there, and they recognized that I was at the firm and had previously worked on the case, and by they I mean the partners in the firm, they asked me as a member of the Supreme Court and appellate group of the firm, which is what was my practice, if I would help review and work on some of the briefing that they were submitting on his behalf, given my familiarity with the case.
Were you representing him pro bono at Morrison and Foerster?
The firm takes on pro bono representations, which means that the person isn't paying. And
let's turn to your amicus briefs. You had 2 briefs in Guantanamo cases, one for a think tank, one on behalf of a group of former judges. I think, as anyone who's done amicus work knows, sometimes the client seek out the lawyer, sometimes the lawyer seek out the client. For either of those amicus briefs, were you involved in any way in seeking or recruiting those clients or suggesting the idea for an amicus brief in the first place?
No, Senator.
Were both of those briefs done on a pro bono basis?
Yes, because the Supreme Court and appellate group in a law firm has paid clients and also has pro bono clients. And the briefs that I worked on were on the one brief was 20 former federal judges who wanted to make an argument in the Boumediene case that was in the Supreme Court. And one of them was a partner at my law firm. She was a former federal judge whose idea it was, and she knew the other judges and wanted our group to work on the brief. The other was not just one think tank. It was the Cato Institute, the Rutherford Institute, and the Constitution Project, an ideologically diverse group of nonprofits who wanted to make arguments in another case that the Supreme Court had taken up related to these issues, because all of this was novel and a lot of issues were being evaluated by the Supreme Court regarding the scope of executive authority during this time of crisis.
Okay, so you've done pro bono work for or on behalf of detainees at Guantanamo Bay. Have you ever done pro bono work for the victims of terrorism?
Senator, I'm not aware of any such cases in my law firm. I was in a group of lawyers that was often approached to ask, would you file a brief for some group? And I'm not aware that any victims of terrorism asked our firm to participate.
So we've talked a lot about the people you represent. Let's talk a little bit about the defendants in those cases and how you characterize them. I'll remind you that those were the President, the Secretary of Defense, and active duty Army officers. Senator Graham and Senator Cornyn said that you called them war criminals. You disputed that, and Senator Durbin has repeatedly denied it as well. And I'll concede you didn't use those exact words. You didn't say war criminals. But you did say in multiple court filings that they committed acts that constitute war crimes. I'm sorry, but I got to confess, I don't understand the difference between saying someone is a war criminal and saying they've committed acts that constitute war crimes. So can you explain that difference to me?
Yes, I will. Thank you for the opportunity. So when you file a habeas petition under our law, you can't file it against the United States because of sovereign immunity. The way our law works, you have to file it against individual officers in their official capacity. That's the way in which you're able to file a habeas petition. So whoever is the executive at the time becomes the named party in the brief. And a habeas petition is like a complaint in a civil case. It's making allegations to begin the litigation about the person's detention.
But Judge, official capacity, personal capacity, all that is just a bunch of procedural gobbledygook. These are the people that you said committed acts that constitute war crimes.
With respect, Senator,
I just don't understand the difference between calling someone a war criminal and saying they committed acts that constitute war crimes.
With respect, Senator, they were not sued in their individual capacity. We weren't making allegations about those individuals. And in fact, over the course of the case, the names changed. So later on, the habeas petition became against President Obama because he then became the executive for the purpose of the habeas petition.
I'm well aware the name changed. It probably changed from Bob Gates or from Don Rumsfeld to Bob Gates as well. But they were not the ones in office. They were not the ones who were overseeing the government when you filed these suits and you said they committed acts that constitute war crimes. I don't understand how you expect this committee to believe that there's a difference between saying someone's a war criminal and saying they committed war crimes.
Thank you for the opportunity to explain, Senator. One of the allegations that had been publicly reported with respect to the group of people who were in Guantanamo Bay was an allegation concerning the use of torture. And when you make that allegation, you bring it under laws that themselves constitute crimes of war. That's the way in which the law works. So if you're writing a habeas petition and you say, upon information and belief, Mr. Al-Qahtani was tortured, that allegation is made under a law that says that there was a war crime that occurred as a result of that torture, and you're making that allegation against the United States, but because you can't sue the United States, the actual petition is named in the name of whoever's leading the United States at the time. So later in the course of this, it moved from President Bush, Donald Rumsfeld, to President Obama. It's not about the individual. It's about the allegation that that Mr. Al-Qahtani, upon information and belief, had been tortured in the lead up to his detention.
I don't know, Judge. Sounds like a debate about how many terrorists can dance on the head of a pin to me.
Thank you, Senator Cotton. Ask unanimous consent to enter a letter in the record from 9 former national security officials defending Judge Jackson's Guantanamo representation. The signatories include former Attorney General Loretta Lynch, Department of Homeland Security Secretary Jay Johnson, and the former Judge Advocate General of the United States Navy, Senator Booker.
Thank you very much.